5 seconds to go. Start. The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require, and this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits, or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decrees, para, provided that the appellate court shall not make any order under section 35A, in pursuance of any objection on which the court from whose decree the appeal is preferred has omitted or refused to make such order. Para. While explaining the scope of rules 23 and 23A of order 41 CPC, in the case of Municipal Corporation, Hyderabad Supra, this court has observed as under, para. A distinction must be borne in mind between diverse powers of the appellate court to pass an order of remand. The scope of remand in terms of order 41 rule 23 is extremely limited. The suit was not decided on a preliminary issue. Order 41 rule 23 was therefore not available. On what basis, the secondary evidence was allowed to be led is not clear. The High Court did not set aside the orders refusing to adduce secondary evidence. Para. Order 41 rule 23A of the Code of Civil Procedure is also not attracted. The High Court had not arrived at a finding that a retrial was necessary. The High Court again has not arrived at a finding that the decree is liable to be reversed. No case has been made out for invoking the jurisdiction of the court under order 41 rule 23 of the code. An order of remand cannot be passed on ipsi dixit of the court. Para. In the case of Sanjay Kumar Singh Supra, relied upon by the learned counsel for the respondent number 1, this court has observed as under, para. It is true that the general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. However, as an exception, order 41 rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. It may also be true that the appellate court may permit additional evidence if the conditions laid down in this rule are found to exist and the parties are not entitled, as of right, to the admission of such evidence. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit, and interest of justice clearly renders it imperative that it may be allowed to be permitted on record, such application may be allowed.